I'm so thrilled that you're with us today, and we want to know about the United States Supreme Court, the history of it, which is truly, truly fascinating, all the circuit, all the things they did on the circuit court and all of that, and then maybe a little bit about how it works toward the end. I know that you have volunteered to give us a little 7-minute or 5-minute opening, so it's all yours. The floor is yours.
Thank you, Janine, and thank you all of you for supporting and being present at this event. And I'm really impressed by what you're doing. I think getting people younger and younger involved in the Constitution is one of the most important things we can do, given the way the world is these days. So we can talk a little bit more about that. I'd like to say I have an inside understanding of how the Supreme Court works. I clerked for Justice Clarence Thomas, which means that there were 4 of us who every year he hires 4 people basically right out of law school. And we serve as a justice's right-hand man or woman, helping them research and draft opinions, figure out how to decide cases. So you get a real bird's eye view of how things work there. So just a few ideas in this very short time before we welcome your comments and questions. One is how important the Constitution is in our country. In other countries, the Constitution is something that gets changed and modified, thrown out, new ones brought in all the time. It used to be a joke. If you wanted to find the Italian Constitution in your library, you should go look in the periodicals section. Youngsters may not know that because they don't know what a library is or what a periodical is anymore. But they change their Constitution all the time. We're unique in this world where we have one that goes back over 2 centuries and hasn't been changed all that much. It's the thing that binds us as a country together, because all of us come from different parts of the world. Our parents all come from different countries. Our ancestors came to the United States, different people, different religions, right? Different political beliefs, different social and economic backgrounds. What do we have in common? We have in common that they came to this country because they loved the freedom of it, the liberty of it, and they have allegiance to this Constitution of ours. The other thing that's really unique about our Constitution, I think, compared to the other ones around the world, is how decentralized it is, how decisions are supposed to be made by the people, by towns, counties, local school boards. Our Constitution creates a government that's not really like the other ones in Europe and Asia, where everything is concentrated in one single government. Our Constitution, at least to me, has a lot of faith in the common sense reasonableness of the everyday American man and woman. Where's the Supreme Court in all of that? Well, as you know, the Constitution creates 3 branches of government. The founders did not think the Supreme Court would be the most powerful branch. In fact, Alexander Hamilton, right? He's the most popular founder right now because they made a musical about him, so he must be important. Alexander Hamilton said the Supreme Court would be the least dangerous branch. He said the president has the sword. The president commands the power of the government. The legislature, Congress, controls the purse. They essentially control the will of and the resources of society. What's the Supreme Court got? Hamilton said all the Supreme Court has is judgment. If you think about it, the Supreme Court has no armies, the Supreme Court has no money. All it can do is issue a decision, and they give a long opinion. You wish maybe some of the other branches of government did this whenever they did something, is issue a long explanation why they decide something. And then they depend on all of us as citizens to voluntarily follow it. So the Supreme Court's real power comes from the judgment and the reasonability of their decisions, not coercion and force or taking money out of your pockets. That's one second point. Third point about the Supreme Court is, nevertheless, it has come to have this great power in our society. If you were to read the Constitution, the Supreme Court comes last. Congress is in Article 1, the president is Article 2, the Supreme Court's Article 3, and that's done on purpose. They thought the judiciary was the least important of the 3 branches. The judiciary was there to decide cases and controversies that arise out of the Constitution and federal law. They thought that the judiciary would be there to restrain the other branches, to protect individual rights, especially when the majority was against the individual. the only place we can go, you and I can go to protect our freedoms sometimes is the court system. But yet the court seems to have gathered the power to decide the most important questions in our society. This term, the court will decide whether abortion is a constitutional right under the federal constitution or whether it should be decided by the states. The courts can decide whether you and I have the right to carry a gun around outside our house, or can the states regulate or even take that right completely away? The courts decided many cases about free speech. The courts starting to decide cases about big tech and social media. They decide a lot of cases about religion. They may well decide a case this year about affirmative action at Harvard that will decide whether we're going to continue using race in university admissions and in schooling. So the question I would ask you at the end is, do we want the court to make all those decisions? A lot of Americans have a lot more faith in the Supreme Court than the presidents or the Congresses or the state legislatures to decide that. But I think if you were to go back and ask the founders, that's the one thing that would surprise them about our courts, is they would not be surprised that the court is there to balance the other branches. They wouldn't be surprised to see the court defending individual rights against the majority, against the government when it's necessary. But I think what would surprise them is that we all of us in society really look to the court now to decide some of our most important social and economic and political issues, when 200 years ago, they used to decide those in Congress or the state legislatures. It's just worth asking, do we like it that way? How did it get to be that way? And I will just close by adding, when you talk to people around the world, they admire that about the American system, that we do put these questions to 9 unelected life-term justices, and they think that might be a better way to decide things than in their own countries. So thank you for the opportunity to just speak a few minutes about the court and the Constitution. And I look forward to your comments and questions and any advice or help I can give for the rest of the period.
Well, thank you. Thank you so much. And all right, my mind is curious now about so many things that you just said. One is that Europe likes it. Tell us what do you mean by that? Europe likes the Dar decision because obviously they're used to monarchies and more power condensed into one person, but what exactly do you mean?
So yes, I think the European system of government is very different from ours. It's actually the one that most other countries have adopted, which doesn't have a separation of powers. In fact, they don't even have a difference between the executive and the congressional branches. They merge them. So in England, there's Boris Johnson, right? That crazy hair guy, the prime minister. He's both the head of the majority party in parliament. He's essentially Nancy Pelosi and Joe Biden together, right? Because he's also the head of the executive branch of government. That's very common in other parts of the world. And so you don't see very strong courts. You don't see strong protections for individual rights in those kinds of systems. What judge is going to stand up against, right, the president and the Congress together, right, wanting to, right, like in Britain, establish socialism at one point. So a lot of people in other countries, I think they admire that we have a system where we do have a strong Supreme Court, a strong judiciary that can stand up to the elected branches when they try to narrow our individual liberties beyond what the Bill of Rights and the Reconstruction Amendments say.
So they're seeing it from a positive perspective, that it maintains our Declaration of Independence, essentially.
Yeah, I think in America, we think of our Bill of Rights and our Constitution as establishing enduring truths, right? Enduring freedoms. I think in other countries, they think, well, we can always change them. It's just words on the page. And they go through so many different constitutions, different versions. They're always tinkering with things. Sometimes they throw it out wholesale. Think, as you mentioned, Janine, in the last 100 years, and even today, there's still monarchies in Europe. They've had fascism, socialism, think of all the things they've gone through. The latest theories of the day. We kind of mosey along with our old-fashioned, slow-moving constitution. But I think because it disperses power and breaks it up, it also means we don't make all the terrible mistakes they made in Europe over the last 100, 200 years.
That's exactly that. We do a 90-day study, 90 essays in 90 days annually. And the study that I want to do this year is exactly that. Look at history, start, go to Greek before our Constitution, Greece, Rome, everything that fell and didn't work. And then look at everybody post our Constitution, all the countries post our Constitution, and look how they fell into, Napoleon, dictators, communism, all kinds of situations that we have managed to avoid. And I credit the Constitution for that we've been able to not fall into the traps that have happened the past 200 and some odd years. So I think that our Constitution is most enduring. Well, obviously, I think that a lot of Americans would feel that we don't want 9 people in the Supreme Court making all these decisions for us, where we have a body that's a congressional body that's represents us much more fluidly than just 9 people. And so it's kind of scary to put. I personally think that it's frightening to put 9 men or women in charge of all of the social issues in our country. But what I think, we talked about this before, and then I would like to switch to history and then turn it over to Tova, who's next. I find it interesting that, I just lost my train of thought here, though.
Can I use a movie analogy to what you just said?
Yeah, please.
So
save me here.
So Forrest Gump. I love the movie Forrest Gump. So remember, there's the love interest, Jenny, the girl. She's always doing the latest thing in the 60s and the 70s and the 80s. She's like Europe. Forrest Gump is like the Constitution, right? Steady. It always saves, actually, Jenny. Forrest is always the same. He's sort of enduring principles. He's a little stodgy. He's a little slower. But in the end, he's the one who's always saving Jenny from falling into all the traps of the latest, coolest thing. And I think that's what the Constitution saves us from. It's the politics of the Constitution are hard. To do anything, you have to assemble a lot of majorities. You got to get a lot of people to agree, got to build a lot of consensus. But that means you don't rush into terrible mistakes. When the government should do something, it's only after we thought about it, and a lot of Americans agree. And the courts help us slow down and not make those kinds of terrible mistakes that we've seen in Europe, that the Jennies of Europe are constantly getting in trouble with.
Very well said. Very true. And our study is really going to focus on that. I'm excited about this study. Well, you mentioned something about opinions. And we gear this in the audience toward people who are young, the youth who are just learning about, the Supreme Court. And the fact, and that's I will always remember that you said that we wish our congressmen and women would issue opinions about the decisions they make. Talk to us a little bit about the process of the court and opinions, and in the beginning that there wasn't even a building and they took it out in the circuit. But talk about opinions first.
So one thing I've done in my career is I've worked in all 3 branches of government. So I've worked in the executive branch and the Justice Department, and I worked as a general counsel to Orrin Hatch in the Senate and in the courts. I've seen each of the 3 branches. And the one thing you come away with is the difference is the justices are the ones who do the most of their own work themselves. So senators have, dozens and dozens of staff to help them draft speeches, help them decide how to vote. Of course, the president has an enormous, hundreds of thousands of people working in the executive branch. The justices each only have 4 people who are right out of school. They're 20. I was only 25 years old, so I was just, barely, I was 7 years out of high school when I was a clerk at the Supreme Court. And so they really are the ones who are doing their work themselves with these 4 kids, essentially, to them, right? Some of these justices are 80 years old and they have like a 25-year-old kid helping them. They're the ones who are deciding. They're the ones who are writing the opinions. So how does it, and they're the ones, so you see them, a lot of what you see is what you get. You can see, any of us can go to the court and listen to an argument. It's not hard to get in. You just show up on time and walk in. You'll see the 9 justices sitting at a bench and a counsel who's only about 3 or 4 feet away from them, answering questions. After they hear the arguments, then they go to a little room called the conference room. Only the 9 of them, no staff, no aides, no recordings, and they discuss how to decide the case. And then, so they count it up. If the Chief Justice, who's John Roberts right now, is in the majority, he assigns who writes the opinion. And then the senior justice in the dissent assigns the dissent. then they write the opinions and they circulate them and they vote for one or the other, and then they announce them. And really what you read in the opinions is why they decided the issue, much more so than any other branch, right? For example, when you hear about Obamacare or you hear about these stimulus bills, you hear about all these deals where someone says, well, what they really did is they put that in there to get the vote from Florida, or to, remember there was like, right, the Louisiana Purchase, because they put in these provisions to get the 2 Louisiana senators to vote for the bill, but they never say so anywhere, right? That's very, in the Supreme Court, you read the opinions. They're very upfront about why they're deciding what they're doing. And it doesn't have to do with where they're from, who they are. It has to do with principles, what they really think the Constitution means. And that doesn't mean they all agree, but they're arguing over what's right and wrong with, I think, without regard to who's Republican, who's Democrat, who's from this state, who's from that state, but because they're all trying to get to the right answer, what's in the Constitution. But the amazing thing is, that's why you could go to any justice and ask them any question about the Constitution. They don't need to check with an aide or pull up their talking points. They can talk right off the top of their head about it because they've been thinking about and working on it themselves. That's really different than the way the other branches of government work.
This is very, very insightful. Very. Lastly, I will just say they're able to do that because of the genius of our founding fathers, the way they set up the judicial branch, that they are not elected.
Yes. So this
and
really,
they're there for life. So they don't feel like, oh, I've got to go keep my constituents happy, or, that gives them that luxury. Cause I was thinking about social media and the 24-hour news cycle, and how so many senators, and they don't feel like they can't ever go make, in the congressional branch or even the executive branch, decisions they really would like to make. They're so worried about how it's going to make them look. They're not really true to who they are or what they might really want to decide anymore. Yeah. But they have that luxury in the Supreme Court because they're not elected.
Yeah, in fact, I forgot to answer your questions about the organization of the court. The key part of it is they have life tenure. After they've been nominated by the president and confirmed by the Senate, they have life tenure and their salary can never be reduced. And the idea was, Alexander Hamilton explained it, was to give them independence, because they were worried, the founders were worried that the president and Congress might get some wild idea and they're going to go crazy for it, and they're going to pressure the judges to uphold it. And they wanted to make sure that the judges would have some spine to be able to stand up for principles, to stand up for the Constitution, even if it wasn't the popular thing to do. The other thing that flows from that is that there aren't that many judges in the country. There's only 9 at the top. Then there's what are called the courts of appeal, and those 9 at the Supreme Court exist only to take the most important questions, or to make sure the court system below it is operating uniformly. So below it, there are what we call the circuit courts. There's 13 of them. There's only 175 federal circuit judges in the country, for a country of 350 million people. And they're called circuits because the circuits are still geographic. So the first circuit includes Massachusetts, the second one includes New York, the third is my home state, Pennsylvania, and so on. I live now in California, which is the 9th circuit, the biggest one. The justices used to ride in a circuit on a horse, and they would start in Washington, they'd go out to the circuit, and they would hear cases all around the stops of that circuit. So we still call them circuit courts. The justices don't do that anymore. The modern judiciary we have is, creation of the late 19th and early 20th century. But in the old days, they would ride a horse. And the idea was, we don't want a lot of distance between our judges and the people. So we're not going to have that many federal judges. We're going to keep the numbers small, and they're going to be where you can see them. So then there's about 900 federal trial judges who are located in the major cities around the country, who do the primary job of hearing initial cases and trials. But that's pretty small when you think that we have a country of 350 million people. And as a law professor, I'm happy to say, and lots of lawyers, lots of graduates of law schools out there, and Americans, Tocqueville noticed this about Americans right away when he visited, even in the 1820s and 30s, Americans love to sue each other way more than people do in other countries. So we have a really small judiciary, a really small federal system to handle all of those cases.
Right. Okay. So I'm going to toss it over to, thank you for that. I just love the idea of them on horses going through their circuit case. All right, Tova, your turn. I would hog all the time, but I have to share.
Thank you so much. Yeah, this has been really fascinating. I think so many Americans follow every move of the president and the legislature, but just don't really pay attention as much to the Supreme Court and judicial branch. So I'm really glad we get to do this. I was just going to ask about how the Supreme Court is able to account for changing attitudes in society, or if they should account for that, since obviously the Constitution hasn't changed other than amendments since our founding, but the laws we have and the rulings of the court have changed a lot, like with regards to slavery or different issues like that. So I guess just how does the Supreme Court, how are they supposed to respond to changing society? Are they supposed to only stick to the Constitution even when it's against what people want? Or like, what was the intention of that?
Tove, that's a good question. No, maybe you'll be asking me in law school in a few years. So this is one of the hardest questions in the law, which is parts of our Constitution are really specific. For example, how old you have to be to run for president. And then some parts of the Constitution are vague, like the 14th Amendment's declaration that states cannot take away your life, liberty, or property without due process of law, and that the states owe everyone equal protection of the laws. And those are pretty vague. So what some people say is on the specific provisions, you got to enforce them no matter. So unfortunately, I think one of the great stains on our history has been slavery. The Constitution tried to prohibit the federal government from regulating slavery, wanted to keep it a state issue, except for the territories. Never mentioned the word slavery, but it didn't prohibit slavery. And so the court allowed slavery to go on. And it was a civil war. It wasn't even the Supreme Court that had to do it. It was a terrible civil war. And the Reconstruction Amendments, the 13th, 14th, and 15th, has finally eradicated slavery. So what do you do as times change with these this general language? I think what the court tries to do is it tries to maintain faith and fidelity to the original principle that the framers had in mind. And then, as you say, they have to apply to new things. So here's a good example. Young people, I think, would be really worried or attuned to this, is do you have privacy on your smartphone? So the founders had no idea about phones. They wouldn't have had any idea about networks. It would have been like magic to them. But they did put in the Constitution a Fourth Amendment that says you and I and every American has a right to be free of unreasonable searches and seizures of our persons and papers and effects, unless there's a judicial warrant. And so just a few years ago, the Supreme Court said in a closed case, even though the founders could never have imagined the internet and cell phones, they did want us to have a certain right of individual freedom, of privacy, where the government can't snoop on us unless it's needed for some kind of prosecution or court order. So they said the smartphone is protected under the Fourth Amendment, because that's kind of like what your house was and your effects were back in 1789. That's kind of how they tried to do it. Now, critics will always say, you're just legislating from the bench. You made that up, right? But I think it was a good faith effort by the courts to try to figure out how to take account of these new circumstances, like the smartphone and like the internet. And I think you're going to see that with social media too. Of course, the founders never had any idea that social media would come along, but the founders and their Constitution have allowed us to regulate other kinds of networks like railroads, transportation, electricity, utilities, even travel. Maybe the courts will compare it to that and say, maybe you can regulate social media the way we've allowed regulation of these other kinds of what we call common carriers. But it's a tough, that's the hardest thing about judging, I think, is how do you take the principles and make sense of them in the modern world in circumstances the founders could never have imagined.
Great, thank you.
Mm-hmm.
And then why specifically are there 9 justices on the Supreme Court? And what's your opinion of some recent efforts that people have been discussing of increasing the number of Supreme Court justices?
So it's a great question. Janine was right. The Constitution says if you're a federal judge, not just Supreme Court, but all 3 levels, you have lifetime tenure. But the Constitution does not say how the court system should be organized. It says there's one Chief Justice, and that's it. So that's always been understood to mean Congress decides, just like Congress decides what agencies of government they are and how big they are, how many employees they have. Congress decides, because it has the purse. Congress is in charge of all the money. Congress decides how many judges there are and how the courts are organized. And so there's no magic to 9. I think it's good that there's an odd number so that you don't have ties, right? But 9 is not set out in the Constitution. This original Supreme Court had 5 or 6. In fact, I think it had 6, which was a big mistake because it was even. Then it would change and fluctuate. We've had 9 since 1869. We've kind of settled on that. I think when it gets too big, the Supreme Court can become like a legislature. You won't have that discussion and deliberation, that tiny little room I was talking about, where they arrive at the decision by arguing together. If it gets too big, it'll just be like voting in the House. Too small and you don't get enough views. You don't get enough different approaches. So something around that. The one thing you mentioned, the demands by some people these days to expand the size of the Supreme Court because they don't like the Supreme Court's decisions. I think the reason it stayed at 9 all these years is because we've avoided manipulating the size of the courts to try to change the outcomes of cases. We tried not to make the number of the justices a political issue. Historically, one president tried to do that, Franklin Roosevelt, in 1937. The Supreme Court slowed the New Deal down in response to the Great Depression. They actually struck down some of the early New Deal bills. And Franklin Roosevelt tried to expand the Supreme Court to 15. And even his own Congress, the Democrat Congress at the time, rejected it because they did not want to politicize the Supreme Court. So no president has really tried to do it since, after FDR suffered that humiliating defeat.
Thank you. That's fascinating. And then could you talk about the system of lower courts in the country and how the Supreme Court interacts with that? Did the founding fathers lay out that system of lower courts, or was that something that came later?
So remember I mentioned the circuit court system. So that really is from the very beginning. That's from 1789, from the very first. So Janine loves the idea of riding the horses around, right? So they don't ride horses. Now we have electronics and we have mail. So the cases get sent to Washington, but we still organize the courts by geography. And we have a certain number of lower court judges assigned to that region. It doesn't have to be that way. Other countries sometimes divide it by subject matter. So you might have like in California, we have family judges and criminal judges and so of different kinds of judges. Our court system is not, if you go into federal court, you can bring in any federal issue. It doesn't have to be a specific subject, but it has to be from that part of the country. If you think about it, that reinforces another feature of our Constitution that's quite different than other parts of which is federalism. We still have states in our system. They're extremely important. And so the court system kind of recognizes that we have different regions and states in the country that can be very different from each other. The Supreme Court's relationship is to take cases from those appellate courts that it thinks are extremely important, or where the circuit judges, they can't agree amongst themselves either. If they can't agree, 99% of the cases end at the intermediate court. The Supreme Court only hears 60 cases a year out of thousands and thousands of cases. And so if the judges below can't agree, and so you have different parts of the country with different federal law, that's when the Supreme Court will also intervene. But in general, the Supreme Court's not there to hear everything. That's the job of this lower court system.
Great, thank you. And how does the Supreme Court decide which cases it rules on? Do the justices decide that, or are there clerks that choose that?
So that's one of the jobs that I had in the other clerks. I guess there are 36 of them. Yeah, that's what they do, is they help the judges. So when a case ends at the appellate court, you can appeal to the Supreme Court in what's called a writ of certiorari. It's called cert for short. So you can send a petition to Washington, please hear my case, justices. So there's so many of them. The justices don't read all of them. Instead, the clerks filter through them. And we try to find the ones that the justices might be interested in. And then we write a little memo to the justices and say, oh, here's this case. You might want to take it because of this reason. The most important one being the judges themselves all disagree about it below. Or like the abortion cases, this is an important abortion issue and you might want to take it now. That's, the clerks give the advice, but it's still only the justices who decide. Now, the interesting little quirk about the system is since there's 9 justices, to win a case, you need 5 justices to agree. But under the court rules, you only need 4 justices to accept a case. So it's an interesting system where a minority of the court can force the court as a whole to hear a case, which gives the minority some rights. That's another thing our system has, is it has a lot of protection for the minority. And this is another good example where you can be on the losing side or the minority of an issue, but you can still keep forcing the court to hear the issue in the hopes that the court will change its mind.
That's so much responsibility for a young clerk.
I know.
That's
I don't know why
amazing.
they do it, but I'm glad they did it because I got to be one. But it's like the
Wow.
Surgeon General had a medical school student helping him with operations or her with operations. That seems crazy to me. I wouldn't want to be operated by a 26-year-old medical school student. But that's the law has that. The Supreme Court has, I think the Supreme Court justices like it because they actually love young people. You should try asking if you can take your students to meet with them. They love meeting with high school students in particular, but they often meet with groups. They love working with young people, I think, because they want, even though, as you said, Tova, how do the justices decide new things? This is one of the ways they learn about what's new. So I can't imagine 83-year-old Justice Breyer was right on top of how to use TikTok, but I'm sure he asked one of his clerks how it worked, right? So I think they want to have the contact with the youngest people in the profession so they can have their finger on the pulse of what's going on in the country.
Okay, we probably need to toss it to Jewel and Jorn now. And our students on our mentor trip did get to meet with Chief Justice John Roberts.
Oh, great.
Yeah,
Great.
that was pretty fun. He talked with the students for about 30, 40 minutes. It was really, really wonderful.
Wow.
Okay, Jewel and Jorn, you're on.
Hi, Professor. Nice to talk to you today. Thank you.
Sure.
So we have bet Jordan has a bunch of questions too. We've talked about the Supreme Court a few times, but never just like this. So it's very interesting. We were doing a series on the Anti-Federalist Papers. One of the Anti-Federalist Papers, which I can't remember offhand, talks about the Supreme Court and the issue of having one court over the whole country.
Mm-hmm.
So I have a couple of questions basically about
this is
that.
Anti-Federalist paper by a guy named Brutus.
Yes, thank you.
What's
And they didn't tell me this beforehand, everybody.
Before the Civil War, can you think of any examples where the Supreme Court had to rule in conflict with a state court's ruling?
So this is this was the major question of the federal courts before the antebellum pre-Civil War period, was exactly what you asked. What is the relationship between the Supreme Court and not the lower federal courts, which what we talk about today all the time, but what's the relationship between the Supreme Court and state courts? So before the Constitution, there was no Supreme Court. Between 1776 and 1789, we had Constitution version 1.0, which was called the Articles of Confederation, which everyone pretty much thought was a failure. That system had no Supreme Court. So each of the 13 states, their Supreme Courts and their own state judges, they could decide however they liked. And there was nobody at the top to look out for the federal interest or to resolve conflicting opinions. And so actually the main business of the Marshall Court, Chief Justice John Marshall is the greatest justice in our history, was to try to establish the supremacy of the federal law system, federal law over state law, and to force those state judges not to discriminate against the federal government, and to ultimately, when it came down to it, obey the Supreme Court. There were lots of justices at the state level who wanted to ignore the Supreme Court or defy it in some way. And look at some of the early cases, maybe one of the most important cases under the Marshall Court was called McCullough versus Maryland, where the Supreme Court blessed the creation of a national bank, the forerunner to the Federal Reserve Bank today, even though the Constitution doesn't mention a bank at all. This is one of those vague provisions called the necessary and proper clause, which the Congress said a bank is necessary and proper for us to do lots of other things like wage war and manage the economy and so on and so forth. In that case, the states defied the federal government. They said, we don't think you have the power to create a bank. We're going to tax your bank out of existence. And state judges are going to protect the state governments as they defy the federal government. And so a lot of the most important decisions of this time were simply to respond to your question by saying the Supreme Court is, in the area of federal law, the final word. And they have the right to review and even reverse what those state judges do. But it took years of fighting between the federal judges and the state judges to resolve that, to the point where today we don't think of it, it's pretty much a settled issue.
Yeah, and it makes sense as to why it was so vehemently argued. And it's a shame that slavery was the lightning rod and that kind of brought it to an end, because the people fighting for state rights or for the ability for the states to operate more or less independently and sovereign were trying to protect a great evil. So any good that might have been in their position as far as state rights is totally lost because they're fighting for it for evil. So if the state rights were going to be able to protect that, well, then who wants that?
Yeah, I think that's
I guess
right.
my question.
Go ahead.
And my question is that while that's true, while we would have to have a Supreme Court to have like a national government, then what is left to do if the Supreme Court does not declare something unconstitutional that we think it was? If, an example would be the founders really couldn't fathom having abortion being constitutional. They couldn't fathom things, many of the government organizations we have now probably being unconstitutional. They probably wouldn't have seen the states of wanting the amendment to have the state income tax, but then they probably still wouldn't see organizations like the IRS and their powers as constitutional. So what's left?
So that's a very good question. And if you've read the Anti-Federalist Papers, I hope you read the Federalist Papers too, because in the Federalist Papers, this was an anti-federalist argument against the Constitution. And this is actually what Brutus said was, what if the government does something unconstitutional? How do you stop it? And Brutus criticized the Supreme Court because he said, well, they'll be in Washington too, and they'll be appointed by the president and Congress. So they're going to sympathize with the federal government. They may not be the great protector of individual rights. And you could say this happened in the pre-Civil War period, right? The Supreme Court said that slavery was constitutional in this terrible, terrible case, Dred Scott versus Sanford. So what do you do? So the Federalist Papers say, well, the first thing you do is you win elections. And first thing you can do is win elections at the state level. And states, states are hardwired into our Constitution. You can't, the federal government itself really can't function without functioning states. Where would the senators come from? Right? Where would the electoral votes come from? Right? Where do even the members of the House and their districts are all state-based? So the Federalist Papers say, yes, it's possible the federal government will do things which violate the Constitution itself. But you have to change the law by electing new people to Congress, electing a new president, and maybe they'll reverse the law. Or they can appoint new judges. Or you could go to states, and states can try to fight back using their own political powers. So what the founders wanted us to understand is that we shouldn't rely only on the courts. I think what they thought is the courts would be first, because we would go to court and say, the Congress is trying to, do something unconstitutional. But it was only the first line of defense, and that there would be multiple other ways to try to oppose unconstitutional action.
Thank you.
Mhm.
Just kind of clarifying something for me, or explaining the reasoning past what you already said, because you had said that they made that the Supreme Court members, you were never removed from office. It was a retirement type once you were elected, and you had said that it was just because so they wouldn't be scared, or have allegiance to the party that put them in, because they are appointed by the president. But were there any other main reasons for this being really the only office that comes to your mind that is a lifetime commitment?
Well, the most important one is tenure for university professors like me. Never take our jobs away. No, but if you look at I think it's a good point, because it really looks at your question, touches on how did the founders think all these pieces would work together, right? So they look at the members of the House of Representatives. They have the least job security in the system, right? They have to return to election every 2 years, right? In fact, if you talk to members of the House, they constantly complain about how they have to always they're always running for re-election. But the founders wanted it that way because they said the House is the one that should be closest to the people. They're the ones who should be reflecting what we want now, right? They want them to be tied closest to the people. And then look at the senators, 6 years. The idea there was they would have more judgment and wisdom, and they would be further removed from the latest issue. And notice that's why the Senate is involved with confirming judges, ratifying treaties, approving a constitutional amendment, or the Senate has a separate role. They're much more involved with foreign affairs, where I think the founders hoped we wouldn't be as political as with domestic affairs. And then look at the president, 4 years. So they wanted the president to be somewhere in between 2 and 6. He would, or she would, still have a tie to the people, but not so distant as the senators. You think about it, there's some senators who've seen 6, 7 presidents go by, right? The justices, they wanted to have absolutely no tie at all to the people. If you think about it, when a court says something is unconstitutional, they're essentially saying the majority of the people are wrong. Right? Because, as a majority, we elect people to Congress and that majority passes a law. Right? They wanted someone who had no allegiance left to the people today. And so that's why they gave them lifetime tenure. Another important thing that goes to your question is re-election. So originally, none of the other officers of government had term limits, right? So you can run for the House till you die. You can stay in the Senate, keep running over and over until you die or defeated. Notice originally the presidency also did not have that 2-term limit. And the idea was the founders wanted people in office to have to face the voters and be held accountable. So we're going to reject you or we're going to keep you. The judges never have to go back again, right? After you're confirmed, you're there, you're no longer accountable to your decisions to the voters. Another example, how they wanted them to be independent. But notice this is the judges are the only branch, the only personnel in the whole system who have that removal, are so removed from we the people, we the voters. And that's all, as you say, just because they wanted them to have some backbone and spine to stand up to everybody else when we all want to do something. Sometimes the judges are the last ones saying, no, you can't do it. And they knew that, the founders knew that would put you under enormous pressure. So they wanted you to remain independent.
Well, thank you for explaining all that. It really makes it come full circle. You don't want when ruling on your constitution, you really can't afford any bias to really anyone. And then I'm curious about the process of cases going directly to the Supreme Court. Now, does that happen? Do cases just go straight there? And what is that process?
Oh, you mean skipping all the lower courts and the state judges and so on? Yeah, so that's really interesting. So that's maybe 0.00001 of all the cases in the country actually can go directly to the Supreme Court. And actually, the Constitution lists them, which ones you can bring into the court directly. And really, the only one the court hears nowadays are disputes between states. So if California sues Nevada and says, we're keeping all the water, we're not sharing any with Nevada, that can go directly to the Supreme Court because it's a fight between two states. You might remember during the 2020 election and during all of the fighting over the electoral votes, Texas sued Pennsylvania. And Texas essentially said, Pennsylvania, you're not following the Constitution, how you pick your electors. So that's the case, Texas versus California. They basically went right to the Supreme Court. That's the only real case these days where you can skip all the lower, because the Supreme Court, they like to take their time. One benefit of going through all these lower courts and these state courts is the justices then have the benefit of seeing all the arguments that are out there and how all the other justices and judges think throughout the country. And so then they have the best advice already, the best argument. So there's a funny word the Supreme Court uses. They call it percolating. They like issues to percolate up through the system. That's an old word that used to be used to describe how these things called coffee makers used to work. It would percolate the coffee, like a bubble up. Now you just tell the Italian coffee machine at Starbucks to make it for you. But in the old days, when people made their own coffee, they would have this weird metal silver thing and the little see-through thing at the top, and you would see the coffee bubbling. It's percolating. So the justices
We use a giant percolator at home.
Really?
There's a lot of them. Yep.
Wow.
Our
Wow,
mom will not
impressed.
have it any other way.
Nope.
So that's how the justices think. They want the issues to percolate through the system. So that's 99.99% of all the cases in the system go that way.
All right, cool. I think it's time to pass it over for some audience questions.
Okay.
Thank you.
Thank you, guys. I do want to ask a quick question before we do that, and we have 10 minutes left, and you're just so awesome. Thank you so much. Can you briefly...
I was going to say, can you audition for the role of my mother? Because I'd love her to say that more often.
Right. Oh, I know. Mothers. I am one, so, and I'm a daughter. Yeah. Okay, so for very, kind of a brief synopsis, because I want to make sure we get to Elizabeth and our audience questions. For those who don't understand the younger audience, the younger students in our audience, talk about where does it start? I mean, we've been talking top bottom.
Mm-hmm.
Walk us through how a case gets to.
Yeah, good point. So one thing about the Supreme Court and the lower courts is that you can't just go to federal court for anything. Like if you're in a car accident, you have to go to state court. To go to federal court and get to the U.S. Supreme Court, you have to have a right under federal law, under the Constitution or some law passed by Congress. So a good example would be employment discrimination. Congress has said that when you get hired for a job or promoted or fired, the employer cannot use race or gender or religion or sex in its decision. So if an employer says, I'm going to hire that white guy instead of that Asian guy because I just like white guys better than Asian guys, that's illegal under federal law. So if I'm the Asian guy and I applied for the job, I can then go to federal court because I have a right under federal law. So I have to hire a lawyer and write up a paper, briefing, we call them briefs, although they're never brief, but we call them briefs. And your lawyer writes it up and goes to federal court and enters it and files a lawsuit. Ultimately, the federal judge can have a trial with courtrooms, juries, lawyers who can say to the employer, did you do this? When did you do this? And so on, get the facts of the case right. If there's a mistake made in that trial, then it goes to this court that Tova is asking for, the circuit courts in between. And they review all those trials all around the country for any mistakes. Only 60 of those cases every year from that level ever get to the Supreme Court because they involve something important. You can imagine it takes years to get from the beginning to the end. So if you brought a trial court, it could take a year or two to get to a trial, and then it could take another year or two to be heard in the circuit courts. So a case from beginning to the Supreme Court can take a long time, 4 or 5 years, some 10 years. Now, Jordan asked a good question. There's some cases move up faster. right? Like there are ways in emergencies to get it through quickly because, for example, some harm may happen to somebody or the government needs to do something quickly. The courts can accelerate the process. But for most of the cases, it takes a long time, takes years and years to get to the Supreme Court. Now, here's a nice little thing. Usually the lawyers really want to argue the case at the Supreme Court. But there are cases where the client themselves say, now that we're here, I'm going to do it myself. You get out of the way. This 1 out of 60 cases, most lawyers never argue at the court, some maybe once in their life. So sometimes there are clients who want to argue the case themselves. That's always the most fun to watch.
Yeah, I bet. Okay, I just have to steal one more question because I'm so incredibly curious. Once our Supreme Court justices are here, not here, well, they see, but they're here, the case in front of them at the Supreme Court in Washington, D.C. They go into a room and deliberate and they make the decision. How long does that usually take? Is it?
So they do it every week. They have arguments. So they have oral arguments, where the lawyers for the clients come and get their chance to answer questions. So it's not like Daniel Webster's day. In Daniel Webster's day, he would just give a speech for 3 days in a row, and the justices would just sit there and listen. Now, oral argument is the justices have questions. They've read all your papers, your briefs, and oral argument is really a chance for them to ask the counsel questions about why they make this argument, or are the facts really, aren't they really this way or that way? And so after that, those set of arguments, they have a meeting that very week, and they usually wrap it up in an hour or two per. So in each case, they might discuss it for like 15 minutes, 20 minutes. And then a lot of the discussion, really the give and take, takes place when they draft the opinions and then they circulate them. And you'll see a lot of justices will say, well, I'm not going to sign on and approve your opinion unless you change this or change that. So there's a lot of negotiation that goes on between that taking of the vote, that conference we call it, and when you see the opinion come out, usually at the end of June.
But it doesn't change their opinion. They make their decision.
Yes, it's very rare. It's very rare to see them change their vote. The opinions, the explanation can change. They can,
because they're worried about what people will see and what they'll think of them. And that's where they're exposed, I guess. But they make their decision in 15 minutes after they hear the case. Usually. Yeah,
15 minutes. They have the meeting that week, the same week that the argument is made, sometimes the same day. And then, we don't really know what goes on because only the 9 of them have ever been allowed in there and there's no records kept. Yeah. But generally, they would go in. What we know is what they've said in speeches and memoirs. They go in and they will argue about it, but they're also pretty clear about what they think. So it doesn't necessarily take too long.
They've made their decision before they get there.
Really. A lot of times, yes. So if you're like Justice Thomas, who I clerked for, he's been on the court 30 years. He's heard thousands of cases probably. He's pretty sure what he thinks about things. It's the newer justices you don't really know. If you're Justice Amy Coney Barrett, who just joined the court in 2020, she's still figuring things out. So she's going to take more time. Yeah.
This is all very fascinating. All right. We have about 3 minutes left, Elizabeth. Sorry.
Right.
Do we have an audience question?
Yes, thanks so much. We've had some great questions and some folks have written, said they plan to share the session with their friends. It's been really informative. So we have some questions from John Chambers, but I'll pick one that I think we might be able to cover in this amount of time. We touched briefly on court packing earlier. Can you share your thoughts on court packing and where you think it might go in the current situation? Is that something that you think will come back up again, or is that in the past with FDR?
No, I don't think it's in the past, but I think for the moment, the move towards it has stalled. President Biden appointed a commission, and that commission was supposed to study reorganization of the court system because if you might remember in the primaries last year, several Democratic candidates said they would actually push to expand the size of the Supreme Court, which would take an act of Congress. Presidents can't do it by themselves. And that commission just issued a draft report saying they didn't think that there should be a change in the size of the number of justices. So if President Biden's own commission has said, we don't think it's a good idea, I think the idea has stalled out for now, but it doesn't mean that it won't recur. It won't repeat. I do think it's a bad idea though, because one, it would make the court very political, right? You would be adding and subtracting judges just for Democratic versus Republican reasons, or Republican versus Democratic reasons. And the second thing is, once you do that, where's it stop? Every time the other party gets in, they're going to add more justices. I think the Chinese Supreme Court has 300 judges on it, right? We don't want to be there. So, and then if you think about what the founders were really worried about in the Federalist Papers, arguing with the anti-federalists, they wanted the Supreme Court to have political independence so that they could withstand popular pressures, political pressures, to defend individual rights, to defend the Constitution against what's popular today. And you could see, if you let the Supreme Court size be expanded or narrowed based on who's in charge, well, the justices aren't going to have that kind of freedom and independence as much as they had before.
Okay, let's see if we can do a lightning round. 60-second. One more question. Elizabeth, if you're there.
Oh, great. Well, we had a question about legal realism. That's probably more than a 90-second question. Your thoughts on that?
So legal realism is this idea that when judges hear cases, there's no right answer. They could always choose one or the other. And legal realism says that the law doesn't necessarily dictate what you should do. So when it comes to abortion, say, a legal realist, or gun rights, say, legal realists will say, well, the law isn't really super clear about whether you should be allowed to carry a gun or not, free of state regulation. And so there's this discretion or choice that judges can have. And then the legal realist says all kinds of things can go in there to persuade a judge to decide one way or the other. That doesn't necessarily have to be legal. It could be sociology, it could be economics, it could be lots of different ways of thinking, but it's not really a legal right or wrong answer.
That sounds like a lot of gray. That sounds so
Yes,
little,
yeah, that's right. It's not black and white. Everything is gray.
a little dangerous. Yeah, I would think. But okay, well, Professor John Yoo, what an honor. This was incredibly special. As I said, I've been seeking you to be on the show for about a year now. So this has been a great day, and thank you so very much.
Okay, thank you. It's really great to be with you. I hope we'll come back again.
Oh, we'd love to have you back again. You may regret saying that. All right. Have a wonderful day. And I thank the audience and all of our great co-host panel. And we'll see you next week. Thank you so much, everybody.